Hi everyone. Nice to be presenting something of my own here as well. So my topic is a bird's eye view to animals in the law. Some of you, those of you who have read my work may have noticed that I'm sort of a system builder. I try to get an overall grasp of concepts and issues and so on. This is sort of an attempt to get a sense of what exactly is animal status in the law, basically. So I've earlier had this sort of I've had a positive account of legal personhood, meaning that I've sought to explain what legal personhood means. And at the same time, I've sort of had this negative mission of attacking what I call the orthodox view, as I here call it the orthodox inventory. And now I'll try to do a more positive thing here as well. So what is the orthodox inventory? It's basically this, probably familiar to many of you. Maybe not this specific picture, but the basic idea. So we have legal persons who are either natural or artificial, as Carolina just pointed out. So natural persons are human beings, and artificial persons are corporations in the broad sense of the term. And then we have things. And this is sort of the traditional way going. I don't think it goes back to Roman law. I think it goes back to sort of early modern era, like Hugo Grotius, for instance, and so on, of understanding like how law classifies the universe. So here persons are understood as right holders, and things are understood as the objects of rights. Sometimes you encounter these two Latin phrases, summa divisio, which means that this is the highest possible classification. So there's like no higher classification of the universe, and tertium non datur, which means there is no third. So there is no third category, and this is in a way true by definition. So here we actually have some features of the orthodox view. This may be familiar to some of you, but I've just been sort of reflecting on it recently. So first of all, it's a formal criterion for determining personhood or thinghood. So it's whether you hold even a single right or a single duty, or whether you have the capacity for rights, means that you're a person, and thereby you immediately transformed from a thing into a person. Then by necessity, there's mutual exclusivity. You can't be both a legal person and a thing, because if you have even a single right, you're a person, and if you have even a single right, you're by definition not a thing. Again, I don't agree with any of this. I'm just saying how people have traditionally understood it. Then it's summa divisio, as already said, so meaning that it's exhaustive and all-encompassing. It purports to cover all entities, so everything in the universe is either a person or a thing, apart from maybe law itself. And already said there's no third category. And this, feature 5 has been bothering me more and more. And this is the sort of what I call the totalizing aspect of this person-thing dichotomy. What I mean by totalizing here is that it's taken to tell the whole truth about, say, the legal status of animals. So, like every time you, read a law review article or whatever on the legal status of animals, and if they try to give like an overall picture of what animals are in the law, they say that legally animals are things, legally animals are property. But that's not the whole truth. It's just one part of animals' legal status. It's a private law approach, and not even a sort of a. I don't think it's an accurate description of even the private law status. I mean, of course, it's a good generalization, but I think this is just one aspect of how private law theorizing has dominated legal personhood theories, rights theories, and so on. And I think we need a sort of more comprehensive approach. And my sort of approach, it tends to be, it's a bit complicated. And I hope I managed to explain it to you here, but this is definitely work in progress. I published something in Finnish about this, but I hope to write something about this in English soon. So definitely welcome any comments. Well, this is not really work in progress yet. This is approximately how I understand the inventory of the universe. So there's persons and there's property, and actually these things should be closer to each other. I once figured out a way to do it, but now I couldn't remember how to do it. It looked quite ugly if you put them right next to each other. But because I think you can be person and property at the same time, at least to a limited extent. And I think there's entities that are neither. So, I mean, I think outlaws are the classic example, but you could also have other examples of entities that are neither persons nor property. I think, for instance, some wild animals, I think, are not property. They're not really persons either, though I think they are maybe at the sort of outliers on the personhood sphere. But anyway, so this is like more general stuff about the person-thing category, to give you a sort of background of what I'm attacking here, and where I'm coming from in a way. But this is then like how I've been trying to conceptualize the legal status of animals. And I think there's a lot of boxes here. I think the way to sort of you can think of this as like how are animals distinctive in a way. If you compare animals to, say, chairs, how are animals different from chairs as on the other hand things, and on the other hand as non-things. So first of all, we get the result that animals are like a special kind of things, but on the other hand, they have other legal positions as well. So first of all, I've distinguished here like anthropocentric and non-anthropocentric perspectives. And there's two categories here in the middle as well, which I take to be sort of in a way anthropocentric, in a way non-anthropocentric. I used to think that this thing is a non-anthropocentric perspective on animals, but after many discussions with Fele Platvort, I've come to realize that it's probably in the middle, or maybe even anthropocentric. So first of all, so what we try to think about here is like, what roles do animals play? What features do animals have that make them into the beings that they are? So first of all, animals are sources of food and other goods that we use we sort of exploit animals in various ways. As a result, we also worry for animal health, but we worry for production reasons. We worry that, what if the animal that I bought has a sickness that will infect all the other animals on my farm, and I will therefore, incur property damage. I will incur financial losses. On the other hand, if we think of, again, compare animals to chairs, animals are biological, meaning that they are similar as we are in being biological. So this means that, first of all, they also pose health risks to us. They can carry zoonoses and so on, and which may cause risks to human beings. But on the other hand, they're also a source of scientific information. So we conduct animal experiments in order to learn more about our own biology. But animals are also autonomous. This is also something that distinguishes them from chairs, for instance. And by autonomous, I here mean something very broad. I don't mean necessarily that animals are, some kind of Kantian rational subjects necessarily. I just mean that animals can do stuff on their own. Dogs can run off, and we can have seeing eye dogs and all sorts of stuff. So this means, on one hand, that we can use animal labor. This is, again, an anthropocentric perspective. And another anthropocentric perspective is that animals can cause damage and disorder on their own, which chairs, again, cannot do. And this has certain implications. Then in the middle, we have, I think the stuff on the left is sort of old. It's old law. Like, human beings have had to think of this stuff for millennia, really. But these other perspectives are much newer, something that law has only relatively recently started sort of considering. So first of all, animals are connection forming, specifically that they form connections with human beings. And human beings value them as companions and as part of human communities and so on. And animals are part of the ecosystem, meaning that we protect animals through wildlife law, through environmental law more broadly, not because they're sentient beings, not to protect them from suffering, but because we want to preserve biodiversity, at least as it stands today. We protect some animals. On the other hand, we kill other animals, invasive species, because we see them as threatening our sort of traditional ecosystem. And then finally, I think a relatively clear non-anthropocentric perspective on animals that's reflected in the law is the fact that animals are sentient beings, which is at least mostly reflected in a non-anthropocentric way. Mostly because I think the fact that animals can feel pain can also be exploited by human beings in, for instance, animal trials. We can actually exploit animals' capacity for sentient beings in very anthropocentric ways. But at least animal protection law is instead premised on protecting them as sentient beings. So what do we do with these 6 categories? I'm not sure if this is going to be helpful at all, but let's try. So there's like a bunch of different areas of law in which these categories are reflected in various ways. So for instance, if we think of the role of animals as production animals, well, that's reflected in food law in various ways. But here, food law must also take into account the fact that animals are biological animals. So there's questions of like hygiene, for instance, and so on. The fact that animals are biological animals, meaning that we can gather useful scientific information by conducting experiments on them, means that this is reflected in animal testing law, which is mostly public law, at least in this country. It's not private law. But on the other hand, animal testing law is also premised on animals as sentient beings. So at least again, like in Europe, we have all sorts of regulations on or limitations on what kind of experiments we want to perform, and this is premised on the fact that animals are sentient beings that we try to protect, at least to some limited extent. The fact that animals are autonomous is currently mostly reflected in anthropocentric ways in the law. So for instance, we have special branches of tort law dealing with questions of what if an animal causes damage, who is responsible in that case. This is clearly an anthropocentric point of view. It's just a matter of humans have incurred damage caused by animals. Who is responsible? If we move to connection-forming animals, or the connection-forming feature of animals, there's first of all these. I think we've already discussed these, or other people have discussed examples of how animals are increasingly being treated as family members in divorce cases, for instance. So this is like I think a new way of understanding animal status, specifically in private law, like a move away from thinghood, at least for companion animals. On the other hand, there are examples of how animals have been recognized as having a non-fungible value for their owners, meaning that if you harm someone else's animal, you're not only liable up to the market value of the animal, but rather you may have to pay for the veterinary costs even if they exceed the market value of the animal. So this is, again, I don't think this is like an example of a non-anthropocentric law, because this is about how owners view their companion animals, what kind of value companion animals have for their owners. But it's still like a new perspective on animals, definitely. And then finally, on the right-hand side, there's first the animals as part of an ecosystem, which is reflected in environmental law, but also in hunting law. And I think hunting law actually combines various perspectives. On the one hand, there's the interest that we have in animal bodies. We want to, at least some of us, want to kill them and eat them. But hunting law simultaneously also protects animals on one hand in a sort of from an environmental perspective to preserve biodiversity and so on. But on the other hand, there's also like more purebred animal welfare law, I think, involved in hunting law. So like some cruel ways of hunting, for instance, may be prohibited. And then finally, the fact that animals are sentient beings is most clearly reflected in animal protection law, which again is not mostly it's not private law typically. It's public law, it's criminal law, it's constitutional law. It's not private law. So there's like a lot of stuff, and some of this is sort of reducible to animal status as things, and some of it isn't really. I think the sort of full picture is much richer, and that's why I'm oftentimes a bit bothered when people say that animals are things. You know, well, okay, the civil code says that in many European countries. We don't have a civil code in this country, so it's a bit more difficult here. But the civil code is a private law code. To sort of a little bit summarize this stuff. First of all, are animals things? Well, first of all, I think thinghood, I mean, many animals are things. Most animals are things, meaning property. But that's only one aspect of their legal status. On the other hand, thinghood is changing, at least for companion animals, for instance. And some animals are not things at all. So I think, at least in Europe, in Finland, I don't think most wild animals are things. They're not res nullius. You can't own them. You can kill them, and then you can own their bodies if they are the kinds of animals that you're allowed to kill. But typically, you can't take wild animals into your possession. It's impossible. It's not. Private law doesn't allow you to do that. There's no legally enforceable claim to wild animals. I mean, this may depend on the country, of course. So this is just like a, even though I've been emphasizing that thinghood is only one aspect of animals' legal status, on the other hand, it should also be acknowledged that it's a very important aspect. And it's also sort of in a way parasitic, or like other areas of law are in a way parasitic on the private law status of animals as things. So for instance, the fact that animals are property is reflected in criminal law in the way that if you steal someone else's animal, you're guilty of theft. So it has sort of these reflections in other areas of law that animals are things in private law. But so it's definitely still an important feature of animals' legal status, but it's not the whole truth. Basically already said most of this stuff, but those animals that are things are their status is still changing in various interesting ways. Traditionally, they have already been special kinds of things, but what we have is like new kinds of ways of understanding their thinghood. And for instance, I don't know if anyone else has been, probably someone else has already said this, but I think companion animals are increasingly, I think, could be understood as irreplaceable things. So things are usually replaceable, but companion animals are irreplaceable, meaning that if I hurt your dog, I can't just, buy you a new one and that be done with it. But rather, I should try to see to it that dog, gets, for instance, the veterinary care that it needs. And some animals are not things. So just to say for the 10th time what I already said, private law status as things is but one aspect of animals' legal situation, and the truth is much more complicated. And even though thinghood is very important, it's not the whole truth, and we shouldn't sort of take it to be the whole truth either. Thanks.